Hey, welcome to Faith and Politics, a show dedicated to discussing issues surrounding the intersection of church, state, and politics, and the examination of whether you are allowing your faith to shape your politics, or are you allowing your politics to shape your faith? In other words, what do you do when God and government come face to face? I'm your host, Orland Johnson. Let me introduce you to our guest panelists today. We have Ms. Melissa Reed, who's the Director of Government Affairs for the North American Division of the Seventh-day Adventist Church. We have Mr. Hill Harper, who's an attorney, actor, and United States Senate candidate for the great state of Michigan. We have Dr. Andrew Polk, who's an associate professor of history at Middle Tennessee State University and the author of the critically acclaimed book, Faith and Freedom, Propaganda, Presidential Politics, and the Making of an American Religion. And we have Ms. Jennifer Woods, who's with us, who's the general counsel for the Lake Union Conference of the Seventh-day Adventist Church. Ladies and gentlemen, great having you here with us and looking forward to our conversation today. You know, there's a piece of legislation that's called the Equal Campus Act of 2023. It's a bill that's been put in place that prohibits funding that's made under the Higher Education Act of 1965 from being provided to any public institution of higher education that denies to religious student organizations any rights, benefits, and privileges. This is one of the issues that's been impacting institutions of higher education for quite some time. And we noticed that there are a couple representatives, Tim Walberg from Michigan, Senator James from Oklahoma, and Senator Tim Scott, who's from South Carolina, that have introduced this act. The whole purpose is that over the past few years, there has been an increasing concern regarding incidents on college campuses where free speech and other free association of students have been restricted due to religious beliefs. And one of the things that these members of Congress want to see is to make sure that we have something that's a little bit more even-handed or a little bit more balanced. You know, Andrew, you sit on a college campus where we see a lot of these activities going, and there's a lot of questions regarding what you can do from a religious organization for a non-religious organization and whether or not they both can peacefully coexist on the same campuses. It looks as though we're seeing a pushback of something that started with the Trump administration, and the Biden administration looks like it's trying to go the other way on it. What have you been seeing on your side? And give us a little color on this whole concept.
Yeah, I mean, on my side, honestly, so I think this bill, what it says, what it's trying to do, they're all good things, right? I think we need to protect religious freedom. I think statistically, for most people, unless you grow up in a large urban environment, a college campus, if you go to college, is the most diverse place you're going to ever be, right? If hearing different opinions, people with different backgrounds, we need that diversity as a nation, I think, and we need to protect the religious rights. My concern of this is I'm not entirely sure why it exists, right? So some background. A case, Woodmar v. Vincent in 1981, Supreme Court case, essentially settled this exact same thing explicitly. University of Missouri at Kansas City, because of some Supreme Court cases in the 1960s, had decided, well, if we allow religious groups to use campus facilities for free, that's a public support of religion, so we're not going to allow religious organizations. The Supreme Court, by far and away, said, no, you can't do that. If everyone's paying student fees, if everyone's there, religious rights, there's no way, because it's a religious group, you can treat them different than any other group. And then the Reagan administration essentially expanded that and extended to secondary schools with an Equal Access Act of 1984 that was then upheld again in 1990 by the Supreme Court, right? Case law is pretty much settled on this issue. So the only thing that concerns me is it seems this is one of those political issues to where it is assuring people that you are attacked, you are under threat, and we will protect you. When I'm just not sure there's a whole lot of threat there other than vote for us and be afraid. So the ideas of it are there. It's also completely settled case law. So I'm not really sure what the point of all of this is, to be honest.
So I think an important component of the proposed legislation, which, as Orland mentioned in the introduction, I represent the Seventh-day Adventist Church and its legal interest down on Capitol Hill. We actually are supportive of the legislation and have been doing advocacy in that space. I think the issue the reason or the impetus that the piece of legislation or proposed legislation has come up is because there have been situations, unfortunately, in the past several years on secular campuses where religious campus entities or religious clubs on campuses have been told by their administration that they cannot require that the leadership of their clubs have support a distinctive religious mission or message. Now, I completely agree with you as far as we have seen those cases go to court, and the law is on their side, but there have been several situations in the past several years where that has, and it's very interesting because, of course, the whole purpose of campus clubs is identity and mission, right? And for the leadership, it makes sense, and so it seems very much that this is happening specifically to religious clubs. You don't see the same situation, nor should you, but you shouldn't see it for the religious organizations, for things like an issue-based organization, like a pro-life organization, or a Democratic Party organization that's available on campus. Of course, the leadership should be required to espouse the tenets of whatever body it is. And I think for us, that's probably the biggest issue that we've seen and the need for the legislation.
Hill, somebody who spent a lot of time maybe in the state of Rhode Island and some of the university systems there, that's also considered to be one of the foremost place where the whole concept of religious freedom, especially in the area of academia, has started to get going. When you see some of this type of legislation or see some of the conversations that are going on, it begs the question on whether or not colleges are being in a position where they're trying to be able to be open for debate, or is this really a little bit more of just more culture or a little bit more politics at work as to why we want to see these things move forward? What have you seen, and what are your thoughts on it?
Well, for me, certainly my college years, going to Brown University, then going to Harvard Law School and the Kennedy School of Government, without question, diversity of thought, diversity of ideas, diversity of religion, diversity of difference and peaceful coexistence and sharing of ideas is paramount in a university setting. So we want to encourage freedoms, right? Without question. Now, we're in that place where, yes, we want to make sure everyone's freedoms are protected and folks can advocate for organizations and create new organizations and not feel restricted from that. But when we talk about somebody who's weaponizing or using politics for a hidden agenda, so to speak, that's when it gets dangerous. And I'm not saying that that's what's happening here, but I'm saying that folks start to distrust motivation when they see too much of it, when something seems to be decided. And yes, obviously, different administrators in different settings are going to try to enact different policies, and then they have to be right-sided and make sure that, okay, when I was at Harvard Law School, we studied a number of cases that kind of fall under this umbrella. Now, were folks still operating outside of what many of the case law would say? Sure, because they're running their institutions the way they want to. Now, is this piece of legislation going to still stop that individual behavior? No. I'm wondering what it's about. I guess it's similar to what Andrew said. I'm just trying to wonder what it's about. And I don't know the answer to that, but it begs that question, because oftentimes what we certainly don't want is legislation that says one thing, but it's actually meaning or directing something else or some type of hidden agenda.
Yeah, I think that's important because the motivation behind the original rule, the rescinding of the rule, and then this bill, I think it causes questions, poses questions for all of us, because I think we can all agree we believe in diversity of thought and we want to keep that free and open, especially in an environment of higher learning. And I think that we can all agree, as Melissa said, about the purpose of this, but it's the motivation, I think, that might be causing pause. But as Melissa said, there are arguments made that there is a reason behind this, that maybe it does add weight to the already settled case law on this.
Melissa, I think the point that you're raising, where we find ourselves fighting because we get these great rules and regulations, but how people handle things in practice becomes very, very different. And what we've also been looking at is that a lot of groups that want to go and just do what they want to do, the thought process is, all right, let's kick it down to the court system, see what they think, because it feels like it's almost a crapshoot regarding what that might be. So the idea sounds like that sometimes we're bringing this up for political purposes. We're trying to have some type of agenda of maybe even look at me because I'm pushing this. But the reality is we're seeing battles where there's students that are in positions that aren't getting to have their free voice there. And depending on what your religious beliefs may be, it may be very different as well.
Sure. And I think we're all on the same page here as far as like, we want to be, to give as many resources and the ability to create community for students of faith on campuses, on public campuses, right? And certainly don't want there to be impediments for them to be able to do that. And I think I agree with you as well, Andrew and Jennifer, that we're in a space where we're just seeing reactionary situations. You know, one administration puts a rule in place, the next administration immediately rescinds it. I will note, as I said, I've sort of been paying attention to that rulemaking process. Is, as you know, when a proposed rule is put in place or there's opportunity for comments. And that happened at the beginning of this year. And there were over 10,000 commenters speaking on behalf of retaining those protections for religious groups there on college campuses. That said, that all happened at the beginning of 2023. There has been no movement from the Department of Education since then. This is obviously not a huge priority for them. And so, perhaps there isn't need for legislation itself. I think that there's probably maybe a belt and suspenders sort of situation, to quote my father, who, in case this law or this this regulation is rescinded, then there will be this waiting in the wings to be able to protect those individuals on campuses.
And Andrew, I would imagine that this belts and suspenders concept is really important, especially when you're a faculty member, and sometimes you're called upon even to be sponsors of some of these organizations, that you get something going, then the next thing you know, there's a question, are we still going to be in effect, or is the speech that we're engaging with from a religious standpoint trampling upon the LGBTQ community that's there? And so trying to figure out how to peacefully coexist and know where you're going to go from one administration or 1 year to another, I got to imagine can be a little bit of a whipsaw from time to time.
Yeah, it's really difficult. And what it does is create a dichotomy of concern, right? On one hand, we're an educational institution, so we care about students, right? Real living human beings, of their freedom of thought, of critical thinking, of deep analysis. And on the other side, there is, will I get sued, right? Or will the legislature come down and have an issue, right? In Tennessee, the difficulty of this that I think we have to find this balance is, right, it's hard to trust the idea that this is, that at least for my Tennessee legislators, are really about religious freedom when they have also previously passed divisive concepts laws where you can't say America is racist or systemic racism exists, or we're banning books that have anything that I don't like, right? We have to at some point both remember that there has to be an even playing field of liberty and freedom, no matter what your beliefs and views are. And it has to be about real living human beings and not just me making my point and getting a win against the other side.
Orlin, Andrew's right. My book in 2007 won the American Library Association Award, Best Book for Young Adults, and it's gone on to be the top motivational book for teen boys in history. And there are some places where they've pulled it off the shelves. The reason why people are distrustful of our government and distrustful of democracy is because they always believe there's a hidden agenda behind what's introduced. Mm-hmm. Yet we have to look in the mirror ourselves as individuals and say, well, why do we keep electing the same type of people to represent us if they're truly not? Because the vast majority of people want every book to be on the shelf, and they want to be able to guide their kids. My son is in second grade. I want to guide my son as to what book I want him to read, but I don't want to block anybody from reading any other book if that's what they choose. Yep. And we understand that the government starts to impose upon us, and it's actually, in the words of saying we're expanding freedom, we're actually restricting it.
I'm going to let that be the last word on it, but I think we're right on point with that. Are we really expanding or are we restricting? And that's the big question we've got to ask. Keeping with our conversation regarding higher ed and academia, there's a case that's called Intervarsity Christian Fellowship USA versus the University of Iowa. And on this particular matter, we have the Eighth Circuit that affirmed the district court's holding that university employees violated InterVarsity's First Amendment rights and denial of qualified immunity. In this case, the university deregistered InterVarsity as a registered student organization based on the university's determination that InterVarsity had violated the university's policy on human rights by requiring its leaders to subscribe to certain religious beliefs. The court agreed with the district court that the university's policy was reasonable and was viewpoint neutral, but not as it applied to InterVarsity. The court explained that the university's choice to selectively apply the policy against InterVarsity suggests a preference for certain viewpoints. Jennifer, we're looking at a situation again where we're starting to see that sometimes you have a policy that's in place, but at the end of the day, policies don't mean anything until groups start to interpret them. And the interpretation of the policy now starts to sometimes bring in a color that may not have been warranted from the very beginning. Can you tell us a little bit more about, what's going on here? And even in some of the roles that you have, there are universities that probably you have to come in contact with and give advice from time to time regarding these type of activities. Share us a little bit of your point of view on this.
Sure. What I found was interesting in this is that, there were 500 student groups like this on campus, right? And for InterVarsity, they welcomed anyone to become a member, but of course they had some requirements that their leaders have to share in the Christian faith. And the school said, no, you can't make any kind of requirements like that for the leadership of your organization, but they weren't applying it across the board. So for example, they have fraternities where you have to be a male to be a leader and a member, or you'd have sports clubs that were particular to who could join those clubs and who could be in leadership positions or political or other ideological clubs. But it looked like they targeted religious groups and minority religious groups as well. And so you had about 40 groups that were deregistered. And so the court was like, your policy, it's fine to have a neutral policy, but if you're not applying it in a neutral way, then that is unconstitutional. And in fact, the Eighth Circuit went on to say that they were hard pressed to find a clear example of viewpoint discrimination. And I think, one thing that I take away from this, besides just like the blatantness of this particular application, is that when we have policies, a policy is not enough. We have to make sure that we're also applying the policy in a consistent manner. And not discriminating based on who we're applying it to.
Andrew, I got to imagine you've seen something similar even on your side of the world there, where we're trying to figure out how do you apply this. But it seems as though the leadership of an institution will have a lot of power in determining what really will, quote unquote, fall into satisfying the policy or violating the policy. How have you seen some of this activity even in your work?
Yeah, it becomes really difficult because it is living human beings who are interpreting institutional policies that, not to be too melodramatic, institutions are often dehumanizing in their very meaning, right? We're an organization, a cog in the machine, and you move through. In this case, I think what Hill said earlier is kind of a key to this. People often think that others, right, people on the other side especially, have this hidden agenda, but we also have to make sure that we don't also have agendas in the way that we interpret these things, right? If it's supposed to be neutral, if it's supposed to be fair and open, we all, as human beings, have a tendency to at least distrust the people who are on the other side or who disagree. And so we will generally assume the best about people who are like us or who agree with us and assume the worst of people that aren't. And this goes on all sides of it. But if we say that our goal is freedom, right? As in this case, religious freedom, we have to use that neutrally and equally as best we can as human beings, hopefully in conversation and open conversation with other people as well. I think that type of openness and transparency is essential here. And again, it's another thing that institutions often have a hard time doing. Institutions aren't generally known for being open and transparent in everything they do because they're trying to protect themselves.
Right.
Orlin, I as I'm listening to this conversation and thinking about this situation, and we're discussing a specific case but there are two other cases that happened, I think, in a short period of time around that, and they were all decided the same way. And so I think that these are all occurring on public college campuses to members of the faith community, the student population there. This is a real opportunity for them to see and experience even firsthand what it looks like to fight for your values, for your freedoms, why it's important to stand up for the freedoms of others, even if you don't have any skin in the game, right? Even if you're not, part of this particular club or organization, why it's so essential that they have the voice and the value to exist. So, I think there can be positives taken away, particularly when we see the outcomes that we have as far as those, the courts determining this is a clear case of discrimination. These organizations should be able to exist. But I think it's a good opportunity to, as I said, to be able to see why it's important to stand up for these values and these freedoms.
Hill, you and Jennifer have, spent law on a campus at Harvard where we're now seeing a lot of students there who are actually getting involved in a lot of different clubs and a lot of demonstrations. Melissa's bringing up that this is a good opportunity for students to learn and to figure out things. One of the struggles that a lot of students are having is they see a lot of issues and they can't even tell who they're supposed to root for. It's a confusing thing. And then when you see them on campus, people are kind of getting a little bit concerned, some of the stuff regarding Israel and Hamas, and they're looking at it from one point of view, but they can't exactly work through the nuances that everyone's trying to place in front of them. What's your thoughts? And then I'll have Jennifer jump in after that.
Sure. So, one thing that gets lost, I think, in discussions like this a lot is foundational, fundamental values, particularly in an institution of higher learning. What do we want the foundational filter to be? And personally, we don't hear this enough. I want that foundational filter to be empathy. I want it to be this idea of being able to see yourself in someone else's shoes, even if it's someone that you may ideologically disagree with or have different life experiences or been taught a different way to think about the world in whatever aspect of your world. And if we think about what a lot of this is based upon, when I was at Harvard Law School, we were always going back to founding documents, particularly in constitutional law, right? And liberty and justice for all. That word "all" is a pretty big catch word, and so freedoms are valuable. I wrote my book, The Wealth Cure. You can't be free if the cost of being you is too high. And the more we start to restrict freedoms, it places a high cost. And the more we have to bring diverse groups, diverse ideas, diverse people together. And that's why that Supreme Court case that's limiting affirmative action. I went to Brown University because of affirmative action. I call it affirmative opportunity. But once I got there, people said, oh, you came out of public schools. You won't be able to compete against folks from Andover or Choate or Cranbrook or wherever. Yet I was the valedictorian of my department because I was given an opportunity to compete with those folks. And then I was able to excel competing with them. So the idea here is everybody's welcome. Everybody's ideas matter. And if we can actually have a position where we celebrate that foundationally, then it's not about sides. It's about listening and hearing and debating and thinking. And that's what college and higher learning is about. So that when you go into the world, you've been exposed to diverse thought, diverse ideas, and you still can think the way you want. No one's trying to change your thoughts, but the idea of to change the way you think about other people's thoughts.
Jennifer.
Yeah, and I think that this is why, free speech and protecting free speech is so important, especially on a college campus or places of higher learning, because we want to be exposed to diverse views. We want to be exposed to diverse thoughts and outside of our own groups, right? And once we start curbing, speech, then we end up in a situation where we're not fully being able to engage with society and being able to build empathy to others' viewpoints. And, it's important that it's not just viewpoints that we agree with. It's okay to be be exposed to viewpoints we don't agree with as well. And so I think going to Melissa's point, this is a learning, a point of learning of the importance of protecting this freedom for everyone, not just those that we agree with.
And I think that's a great point, that really what we're seeing here is, and I would describe it this way, Melissa, is teaching moments. These are teaching moments for putting in front of our students to help them to understand that we expect your voice to be out there, but we want to see that you will also learn the nuances of how to be out there, and understanding that, someone else's voice is just as important. Our society leads us to believe that my voice is the most important. Hopefully this will cause things to move a little bit in the other direction. Hey, Jennifer, tell me something I don't know.
Sure. Did you know that our current House Speaker, Mike Johnson, was once a law school dean?
No, I did not know that. Andrew, tell me something I don't know.
This is a historical tidbit because all three of my young children are sick right now. One of the most popular remedies in the 19th century was a concoction called Mrs. Winslow's Soothing Syrup. It was supposed to be especially good for babies who were teething, if you had a sore throat or sore stomach. And then the late 19th century, we found out that's because its two most active ingredients are alcohol and morphine.
No, I wasn't aware of that. Melissa,
I have not given that to my children, but
I was going to ask.
there.
Melissa, tell me something I don't know.
Yeah, Orland. So we talked about Intervarsity Christian Fellowship today. So their origin date is 1941, but they actually point to the roots of their movement back to students on campus at the University of Cambridge over in the United Kingdom in 1877.
Wow, didn't know that. Hill, tell me something I don't know.
Orland, your audience may not know that for the first time in 30 years, Michigan is going to have an open U.S. Senate seat in 2024, and I will be running for the Democratic nomination for that open seat. And unfortunately, for the first time in 57 years, Michigan does not have an African-American representative in Congress. And so we're going to solve that by getting me elected, hopefully, to the United States Senate.
Oh, good to hear that. Well, ladies and gentlemen, thank you for that information and great conversation today. And thanks again for you being here with us. Hope you enjoyed our conversation. Just remember, if it's about God and government, it's faith and politics. See you next time.